What if I tell you that from July 2024, India's criminal justice system will be governed by two different set of laws? Cases registered before and after 1st July will be two separate categories. And as per a lot of constitutional experts and lawyers, this is going to cause major confusion and chaos in India's courts. Not just confusion, after 1st of July, the process of attaining justice is allegedly going to be delayed. And all this under the pretext of delivering swift justice. I will try to entangle this complex issue in 6 simple points with some help from the legendary lawyer Indira Jaising. My name is Zeeshan Kaskar and you are watching The Wire. On 16 June, India's Law Minister Arjun Ram Meghwal announced that the Indian criminal justice system, governed by Indian Penal Code, which is the IPC, and Criminal Procedure Code, which is the CrPC, will be replaced by the Bharatiya Nyay Sanhita, which is the BNS, and the Bharatiya Nagarik Suraksha Sanhita, which is the BNSS, respectively. This is for the first time since the 19th century that there will be a complete overhaul of the criminal justice system. The fundamental motive behind scrapping old laws and bringing new ones, as per Home Minister Amit Shah, was to, and I quote, free people from colonial mindset. So much for the entire overhaul of the criminal justice system, but in reality, out of the 511 provisions originally in the IPC, only 24 sections have been removed and 23 new sections have been introduced. Additionally, approximately 95% of the CrPC has been cut, copied and pasted as the new BNSS. So if majority of the provisions of the law are going to be the same, why was there a need for this so-called complete overhaul? We talk about 6 key things that are wrong with the new criminal laws in this video. Point number 1, the arbitrary nature of passing the law. The new laws were passed in December 2023, last year, at a time when 144 opposition members from both the houses were suspended. The new laws were passed within minutes without any discussion on them. The new laws were sent to the Parliamentary Standing Committee, but dissenting voices were not considered. Thus, the foundation of the new laws was itself is problematic. Point number 2, sedition makes a backdoor entry. Amit Shah, in his parliamentary speech in December, proudly exclaimed that the government is doing away with the age-old sedition law. But in reality, what the government has actually done is they have just removed the word sedition from the laws and have replaced it with a more stringent one. Section 152 of the new BNS deals with an act endangering sovereignty, unity and integrity of India. While the earlier law made no reference to the sovereignty and integrity of India, the new law introduces this as an offence for the first time in the revised Indian Penal Code, which is the BNS. Indira Jaising says that with the new rules in place, an ordinary riot can be elevated to the level of an attack and the sovereignty and integrity of India. Listen in to what she said during an interview with Karan Thapar on this topic.
Now what they've done is, by using the words sovereignty and integrity of India, I'm affecting the... They have actually introduced this offense of being anti-national into the law. What they have been saying in the public domain, everyone is anti-national. Now, of course, you say anything that they disagree, which is against the official line, that is against the sovereignty and integrity of India. So it's a very, very serious matter which directly impacts the freedom of speech and expression. It directly impacts your right to dissent.
Now, point number 3, registering FIR no longer has become mandatory for the police. This is one of the major problems with the new law as per many experts. Congress's Manish Tiwari points out that due to the new rules, the marginalized sections of the society will find it difficult to file an FIR. Let me explain how. So till 2014, police officials were not bound by the law to register an FIR. This led to a lot of corruption in the police force. But the landmark case of Lalita Kumari versus the state of UP, the Supreme Court decided that the police must file an FIR if someone reports a serious crime. However, in rare situations like when the complaint seems to have bad intentions or there might be business competition involved, the police can do a preliminary inquiry before filing the FIR. But now from July 1st, for offences that carry a punishment of 3 to 7 years of imprisonment, it is up to the station house officer, which is the SHO, to decide whether to file an FIR or not. This gives the SHO significant authority in these cases, making them the ultimate decision maker. Indira Jaising explained the importance of an FIR in the eyes of law. Listen to what she had to say.
Why is it called first information report? The word first is important, right? Because the law recognizes that what you say spontaneously is the truth. What you say after a period of 15 days or 20 days can be doctored. You can be doctored by the police, you can be doctored by your friends, your relatives, to add mirchi masala to the information. This is the importance of the word first information report. The moment something happens to me, I go right to the police station and make a complaint, and they have to record it. Now what will happen is no need to record it. And during this interregnum, either you can, the police will be taking bribes to say, all right, you give me this much money and I will register the FIR. That was the reason for going to court in the first place. The police were not recording first information reports. They were becoming like mediators. And this is what will happen during this period, that they are not recording this information. They'll try and mediate between the accused and the person who made the complaint and say, why don't we just settle all this?
So now point number 4. Amid old versus new, justice is delayed. The entire point of the overhaul of the justice system was to provide speedy justice, but on a closer look, we see how the laws will ultimately delay the process of justice. Indira Jaising said that starting from July 1, if no changes are made, two different criminal justice systems will be in place. Substantive laws can't be applied to the past events, but procedural laws can be unless they harm the accused. Each case might argue that this harm, leading to long delays before the Supreme Court decides. Until then, we won't know which law applies to us, causing uncertainty about our rights. I'm just quoting Indira Jaising here. This will increase the workload of the already overwhelmed judiciary. There are 83,000 cases pending as per the national database, and this will cause even more delays. No assessment has been done to understand the impact of the three new criminal laws on delays or the improvements to the criminal justice system. Ms. Jaising, in the interview with Karan Thapar, very lucidly explained how this issue about two parallel justice systems will hobble things. Let's understand how it will happen.
For every single first information report which has been filed prior to 1st July 2024, it is the old substantive law that will apply. For the FIRs filed after 1st July, it is the new substantive law which will apply. But the procedure, there will be a dispute in every case whether I should be tried by the procedure of the old procedural law or the new procedural law. Representing an accused, I can say the new law is prejudicial to me. So the courts have to deal with both the old law and the new law, which is the reason why we say that the Indian Penal Code is more than a century and a half old. And so is the Criminal Procedure Code, though it was amended in 73. It has received judicial interpretation at the hands of the Supreme Court of India, and therefore there is a certainty about the law in relation to the Indian Penal Code and the Criminal Procedure Code to the extent that it's possible. To achieve that level of certainty for the new law, it's going to take another 50 years.
Now, point number 5, new laws raise concerns about arbitrary detention and abuse of power. These new laws bring big changes and also worries about custody and bail. Section 187(3) of the BNSS lets police ask for custody up to 15 days at any time during a 60 to 90 day period, even if the accused qualifies for bail. This could lead to longer detention and possible misuse of power. Previously, if the police did not finish their investigation in 60 or 90 days, the accused had the right to default bail. Police custody was also limited to a total of 15 days. However, Supreme Court rulings have been unclear about whether this 15-day custody must be within the first 15 days or can be spread out over the 60 or 90 days. Despite the changes, Section 167(2) of the CrPC still limits police custody to 15 days. But the new rule in Section 187(3) might weaken this safeguard, adding more burden to judiciary and leading to longer detention, complicating the justice process. Point number 6, the digitization and technology myth. Amit Shah's December speech in the parliament Amit Shah's December speech in Parliament was focused on how the new laws will transform the justice system by digitizing everything from FIR to judgment. He said that the country plans to have a completely digital criminal justice system by 2027. This will be discriminatory for people who do not have access to technology and internet. It will also put the marginalized section to a disadvantage, similar to what we have experienced after the Manrega scheme was digitized. Moreover, 100% digital connectivity is still a distant dream. However, experts believe it to be far from true. The Home Minister also said that focus will be on forensic sciences and that every crime scene will be mandatorily visited by a forensic team. However, lawyer and criminal law expert Abhinav Sekhri writes that promotion of forensic science as a crime solving tool is misleading. Globally, many forensic practices like handwriting analysis and fingerprinting have been questioned for their scientific validity, leaving too much room for subjective interpretation and potential manipulation by the authorities. The BNSS also allows for longer police custody and makes getting bail harder. This goes against the idea of using forensic evidence because it still relies on getting confessions from people who might be pressured in custody. In short, while the BNSS claims to support modern technology and forensic sciences, it actually makes things worse by allowing longer detentions, which creates problems for the justice system. So, these were the 6 big things which are wrong with the new criminal laws that will be in place from July 1st, 2024. Many lawyers have written to the CJI and opposition leaders to raise the issue and not allow the new criminal laws to be implemented. That's it from me. There are many more intricacies about what amounts as a terrorist, seizing of digital gadgets, etc. All these topics would be difficult for me to cover in a small video, but these 6 points which I tried to put in are the most disturbing facts about the new criminal laws. That's it from me. My name is Zeeshan Kaskar, and you are watching The Wire.